chapter because without litigation, how do you enforce the laws? So 3.1, it gives a great overview of what's involved in litigation. Definitely go through it and understand everything. This is a very high level um, presentation that I'm providing here, but litigation and in law, there are all these legal terms. Try to do your best. Any defined or bolded term is important for you to understand. Maybe fair game for the final quiz or any test in this course, but essentially do your best. But I think the most important thing about understanding these legal terms is understanding what they mean and understanding how it's important for business and for law and for society. So litigants are the parties in any litigation. Basically, in any case, there's two sides. There's party A, party B. It can get more complicated if there are more parties, but typically there's just a defendant, and one plaintiff. One plaintiff or the prosecution in the criminal case, and then there's the defendant on the other side who is being sued. Um, some cases involve multiple plaintiffs and multiple defendants. For example, a class action, right? One, you may have gotten a text once saying, hey, Nintendo, or hey, Pokemon Go used your privacy or violated your privacy, and we're suing them, and you're a part of this class action. And do you want to participate, or do you want to get money do you want to be a part of the class? You can get money from the lawsuit. And recently in 2024, 2025, there was a Pokemon Go settlement where if you were a Pokemon Go player during a set period of time, you may have received $150 or something from the class action settlement that happened. As we can see in America, you have these class action plaintiffs who go after these companies because $150 to me, is that worth it for me to sue like Niantic, the creator and the operator and the owner of Pokemon Go? Is it worth it for me to do that? No, because it's $150, and litigation is like hundreds and hundreds of hours, like hundreds and thousands of dollars, if not millions of dollars, to pursue a case against a defendant. So that's why you have class actions where you have these firms that represent all these plaintiffs so that they can go after the company, and then they get a big cut. But then also plaintiffs like you or me, if we're a part of the class, can get some money too. So claims or causes of action, if you're in California state court, they have to do with the different theories of any legal right that you have that you believe was violated and caused you damage that you're now seeking compensation or a remedy for. Understand, the different terms involving multiple parties. Attorneys are and lawyers, they are members of the bar. They are the ones who are authorized to practice and argue cases in front of a judge. Any person who's representing himself or herself or their self in court, that would be a plaintiff in pro se. They are also referred to as pro per plaintiffs sometimes. And jurisdiction of lawyers, when you are barred in a certain state, that means you can practice in that state. Or if you are licensed to practice, you can also apply to be to any district court. So you can apply, so you can practice in the federal court system. But for the state laws, and for states, you need to pass the bar of that state. You need to pass the California bar to practice in California. You need to pass the Texas bar to practice in Texas. You need to pass the New York bar to practice in New York. And some states, they are a quote UPL state, where such as New York, where they, along with other states, if you practice in one state, you can practice in the other states. But in California, we have the California bar. If you are a California lawyer and you're practicing in California, you had to have passed the California bar, which is known in the country as one of the most difficult bars to pass. Yes. Client-attorney relationships, very important. Attorneys always have obligations separate, to their clients, no matter what. It doesn't matter if, for example, your client is no longer your client or they choose another attorney, you still have obligations to that client as an attorney who used to represent them. If a client cannot pay you, you still have to represent them to the best of your abilities, but you can initiate sometimes the process of no longer providing services for that client because an attorney does have to get paid. So just understand that there are, these are all relevant, because if you're a business or for business law, it's very relevant. A business business, sometimes you need to hire an attorney. You need to understand what attorneys do, right? Because attorneys are the ones who can advocate for you or defend you in a lawsuit. And, what are their obligations to you or to, the other company or to the person who's suing you. Privileges are important to understand. It basically says, hey, for example, spousal privilege. Say you're married and you are, the party in a lawsuit. You're the plaintiff and you're suing a company. You're suing your former employer and you're the employee. The company cannot ask you what you and your they can ask you what you and your spouse talked about, but that is protected communications because you two are spouses. And you can assert the spousal privilege. Same thing for doctor-patient. Like, I have a therapist or you have a therapist. If we have therapists, no party can ever ask, can force someone to force a doctor to tell them what you told them in therapy. Unless there are some exceptions, unless you make that for example, your emotional and mental injuries a part of the law, so you make it the issue. But in general, there are exceptions to every privilege, but overall, this is what a privilege is. Duties of lawyers, understand what that means. The types of juries. Juries are fact finders, so they are jury duty. It means you gotta go through the process, potentially be selected to be on a jury, and there are different types. So key takeaway here is civil litigation. The goal is to find the truth, to make someone whole. Lawyers are typically used almost always to, for the civil litigation process. There are rules in place to make it easy for people to file a lawsuit or to make sure we understand how we do it. And it's important to understand that lawyers are always bound to their clients to represent them to the best of their abilities. But their highest duty is, of course, the administration of justice. So they cannot, a lawyer is ethically prevented from ever telling a client to break the law, for example, especially, like for criminal law, where it depends on the situation. But overall, you cannot ever tell, like as a lawyer, you can never tell your client to lie to a court. That's not okay. So yeah, understanding the differences here and what a jury is as well. Standing, very important concept, because if you have no standing, you cannot bring a claim at court. Understanding how to demonstrate standing is very important. The case needs to be ripe, it needs to be moot in order for a court to be willing to hear it. Personal jurisdiction has to do with the court's ability to have power over or authority over the parties in the litigation, over the specific parties of the specific people. Minimum context required. Venue is important to understand. So for example, fairness is a concept that comes into play here, because if a person in California sues someone in Florida and they sue the Florida person in California Superior Court, it would probably be unfair to force the Florida resident, the Florida defendant, to fly all the way over to California and to San Jose to go answer a lawsuit, right? So that's a very simplified example, but in general, personal jurisdiction is important because it has to do with fairness. You shouldn't, unless there is a reason for someone to be in front of a particular court. The court, well, let's say the court must have personal jurisdiction over a person in order for them to in order for the court to make a decision that would apply to that person. It's a constitutional requirement as well. Understands the concepts here. Service of process has to do with being served a summons and complaint, understanding that you are being sued because if a plaintiff files a lawsuit in court, but then does not serve the lawsuit on you, does not give you the papers, does not inform you that the lawsuit is happening, it would not be fair for a court to rule on a lawsuit that that the defendant is not even aware of. So that's why there are procedural requirements where the plaintiff would have to sign a document attesting to the court saying, "Hey, yep, I sent my complaint, I sent my lawsuit over to the defendant, and they know about it." Some difficult concepts, but work through them to the best of your ability. Pretrial procedures are important, class actions, issues facing parties during discovery. So in litigation, there are essentially a few parts here. There's pre-litigation, so that's what happens before a party sues another. And then there's actual litigation. What are the different phases of litigation? How are they different from each other? And how the process typically goes in terms of a timeline. So pre-trial, before we get to trial, you have issues relating to standing. Does the court have subject matter jurisdiction? Does the court have personal jurisdiction over the parties? The litigation begins when a complaint is filed in court, right? But then it continues. One of the next steps is the plaintiff files the complaint. After that, the plaintiff must serve the complaint on the defendant. The plaintiff must serve process, right? The service of process is when the plaintiff hands the complaint and the summons to go to court to the defendant, or mails it in some way, or basically the defendant must know about it. The complaint has different components to it. It has the factual background of why they are in court. It has the different legal theories, the causes of action, the claims of how the plaintiff believes they're injured, and it has the prayer for relief, the damages. For example, for a breach of contract, the damages may be, the prayer for relief may be to compensate, to pay the plaintiff what the defendant owes the plaintiff under the contract, or to that specific performance, injunctions, all important. Understand the process of how a complaint is filed. After a complaint is filed, the defendant typically files an answer saying how they do not believe the claim has any merit, or they're not sure, basically providing all the possible defenses that could apply. The answer admits things that they agree are true. They talk about how the defendant is related to the plaintiff, and basically defenses. It's important because if you don't say things in answer to a complaint, a defendant may potentially not be able to make that to raise that defense later on in the litigation. Motions are important, like for example, a motion for summary judgment, a dispositive motion, motions, motion for summary adjudication. These basically tell a plaintiff, or if they're granted by the court, it can basically the lawsuit could be dismissed because the court will say, oh, this complaint doesn't have, or this cause of action, this legal theory doesn't have any merit. So plaintiff, you cannot sue on this legal theory. Understand statute of limitations, understand what declarations are, what affidavits are. Declarations, affidavits, they're the same thing. It's basically you sign a document in writing saying, I attest to the truth under the laws of the state of California and the laws of the state of the United States that this is true. Discovery is the most expensive part of litigation. It involves a lot of exchanging of documents, information. There are requests for production of documents. There are special interrogatories in state court, interrogatories in federal court, requests for admissions, form interrogatories, depositions, subpoenas, all of these different discovery devices to help each side obtain all of the information. Because the purpose of discovery is to understand all the facts so that the case can be decided on the merits of all the facts, not, gamesmanship or hiding evidence. And a lot of motions are involved here. For example, if one side says, hey, no, I'm not giving that to you, and the other side says, hey, no, you need to give it to me, and the other side says, hey, no, I'm not giving it to you because it's protected under this privilege. And then the other side says, no, that's not true. And then there's a dispute, and then they file a motion. The judge hears the motion, and, then it's a long process, and so there's a lot involved here. Yeah, so key takeaway, litigation is expensive. The court system, there are procedural rules that help make sure that it goes as fast as possible, as efficiently as possible. Certain claims cannot be brought. For example, if the statute of limitations is passed, that means that you waited too long to file your complaint. If you like a 1-year statute of limitations means, for example, that you can only file a complaint from 1 year from the date where you were injured. Otherwise, you can't sue them anymore. Different discovery methods. The important ones are interrogatories, production requests for production of documents, so document production requests for admissions, and depositions. Jury selection is 3.4, and opening and closing arguments, at trial. Trial is, what we think about when we think of cases being litigated in front of a court, when we see it on TV and it's your honor, or to, telling the jury that this person is guilty, or you're saying this person did this or that. We'll see what happens. Yeah. We had sometimes it's televised if it's an important one of national interest. For example, the Luigi Mangione case will definitely be televised, I believe. And then, we had Amber Heard and Johnny Depp. We'll probably see it with Justin Baldoni and Blake Lively. These are, pop culture cases. Sometimes, even if it's important, it may not be televised, but typically they are, if it's like, something of big national interest. Understand the process of challenging a juror or a jury. Understand how trial begins. So one side begins with an opening statement. You have cross-examination of witnesses. The jurors, the members of the jury, have to listen to it. There's direct examination, cross-examination, and different types of ways that a case can go. So a jury deliberates, then they render their verdict. Sometimes you'll see an appeal after this, and that might be covered in a different chapter, I believe. But overall, lots to litigation, and it's a really fun process, a really fun and exciting area of law, and it definitely drives a lot of what we see in what we think about when we are creating employment policies or employee manuals, or making sure contracts are performed. There's performance on a contract, or you follow the law, and because litigation is the enforcement mechanism behind all of this. Because if you break the law or you don't do something you're supposed to do under a contract, you're right, that's private law, a contract. One of the parties can go sue you, and that is a very, very, very expensive process, on top of the injuries that the party sustained from because of the actions of another party who didn't perform on the contract, or who in some way violated the plaintiff's rights. Okay, and so that is the chapter on litigation.